Hi, I'm Rajitha Navaratna. My student number is PRT 3248.
And we are here to do a presentation under the subject of Business and Corporation Law. And these are my group members. We are solving a problem type case study into the section of agency relationship and the partnership relationship. So I'm gonna start with bit of explanation about agency relationship. Agency is a relationship of three parties: the principal, the agent, and the third party. An agent is a person who is authorized to create or establish legal relations as an intermediary between a principal and a third party, leaving the principal in the binding legal relationship with the third party. The relationship between the principal and the agent is a separate contractual and mutual relationship. If we talk about furthermore, the principal and the agent create an agency relationship. This is a business relationship where a principal gives legal authority to an agent to act on the principal behalf when dealing with the third party. An agency relationship is a fiduciary relationship. So we are going to solve the case called Swimming Pool Co. vs. Mr. Martin case study. The issue of the case is if the principal, which is Swimming Pool Co., is liable for the action of the agent, which is Mr. Martin in this case. So the rule was raised. The rule regarding the liability of the principal is case of agent states that rectification of the agent action will have to be carried out when agent acts beyond his or her power. It is important that agent is acting on behalf of principal at the time of contracting, and the existing of principal is ensured, and the principal was not in any kind of disability from getting into contract. So the questions arise: is Swimming Pool Co. liable for Mr. Martin's action? Yes, the principal is liable for agent's action. Mr. Martin was appointed to get into contract with the client on behalf of the principal. Principal asked the agent to carry out certain tasks, which include quoting the price of pool installation, draft a new contract, and reserve the advance and deposit the same in company's bank account. He is witnesses to have been carried out activities he was not authorized to do. Company to do. For instance, he gave an advice to, and the funds collected and not been deposited into the companies, but the same had been routed to his own business. So apparently he has acted beyond the authorized given to him by not only providing incorrect information to customers, but by embezzling the company cash for his personal interest. As a conclusion, considering the entire analysis in relation to the rules, we are of the opinion that principal is liable for all the damages occurring at the premises of the customers. And the rest of it will be continued by my colleague Ruani. Thank you.
Thank you, Rajitha. My name is Dasanayaka, DMMR, and my student ID is PFEC3488. I'm going to explain the principles, prove that agent act beyond his powers, and the liabilities of Mr. Martin towards Swimming Pool Corporation. Furthermore, I will be explaining the breach of duties agent planned to set up his business. Moving on to the slides. First of all, we have to find out, can Swimming Pool Corporation prove that Mr. Martin acted beyond his powers? The answer is yes, because under the common law, it states that the principal the agent made the statement is not at all associated to the responsibilities delegated to the agent. The rule has been established in the case L. Shaddock Associates versus Parramatta City Council. At the same time, it has mentioned in Consumer Act 2010 states that the agent are not allowed to provide any information that is misleading for third party. When we analyzed, we found out that Mr. Martin was not asked to provide any kind of advice. He was only asked to carry out three main responsibilities that had been given to him on behalf of the principal. By the court, Lego versus Brown Bureau Limited case, Swimming Pool Corporation can establish the breach of authority to Mr. Martin by providing dishonestly implied that he could act in the certain way, and also the representation made by Mr. Martin compelled customers to sign a contract and the information was wrong, and later some of the customers would have ignored signing the contract if representation was doubted. Therefore, as a conclusion, the opinion is that the principal can establish that agent was acting beyond the authorities given to him. Moving on to the next slide. Now we have to consider whether Mr. Martin liable to Swimming Pool Corporation. The answer is yes, because the agent is liable to the Swimming Pool Corporation for all the acts he has carried out. Here, the agent required rule is duties towards the principal in order to ensure that he satisfied his liabilities towards the principal. Under the common law, agent has both contractual and fiduciary duty for the principal. A fiduciary duty is considered a multitude of relationships and arrangements under law. After the analysis of this case, we observed that agents have broken many contractual duties and fiduciary duties. For an example, the customers were given incorrect information which had resulted in increase in liabilities for the company can be mentioned. Besides, the agent is making his own company and routing the cash collected from the customers of Swimming Pool Corporation. Moving on, the main concern is that any duty of agent is breached if he is planning to set up a new business. The answer is yes. Under the common law, it states that the conflict of interests arises where agent carries out his interests instead of the principal's. Moreover, personal business and make it stand against the principal's business. For an example, the customers were given incorrect information which had resulted in increase in liabilities for the company. Then Mr. Martin had started his business secretly and developing it at the expense of company. He was doing it to launch a competitor to the Swimming Pool Corporation. So as a conclusion, we can come up, it is explicit that he was executing his personal interests and he is in breach of his duty by setting up his business. The rest will be continued by my colleague Sharman.
Thank you, Ronnie. Hi, I am Sharman Prasanna. My student number is TGO3017.
There are two types of partnerships can be recognized. First thing is general partnerships and second thing is limited partnerships. If I talk about relationship between partners, so we can examine few terms in internal relations between partners. First thing is fiduciary duty of utmost good faith. Second thing is rules to the interest and duties of partners. Third thing is variation of the partnerships.
rules by consent of the partners. Fourth thing is what constitutes partnership property. A part of that, another few more terms can seen in the slideshow. Then we discuss about possibility to exist a partnership between among friends. So, according to the common law, few rules can be recognized about the existence of partnerships. Basically, it's consider three things. First thing is intention. Second thing is parties should have written agreement, and third last one is behavior should have explained. When above rules satisfied, partnership will exist. So therefore, exactly partnership can exist among friends. Then we discuss commitment of seamless to fast cut and partnership liability. According to the common law, partners of partnership should share unlimited liability, and each partners have power to blind the firm. Each partners of a partnership is both principal and agent. So my colleague Gishan will continue the rest of part of the presentation. Thank you.
Thank you, Sharman. My name is Kishan Herat. My student ID is TGO3029. As per common law, having a written agreement of partnership is not necessary, but keeping a written agreement makes business operation efficient. Written agreement included about several important details such as name, address, how profit sharing, how to dissolve the partnership. As per this case, this business registered, and they have already the written agreement. It mentioned all the details about the partnerships and their address and such as things. So fast cut can find clearly the names behind the partnership by the reviewing the written agreement. Moving into the next slide. In this slide, as per the common law, indicate that the death of a partner, it will be dissolved the partnership, and as per this case, the death will be dissolved the partnership. Moving on to my next slide, it contains how the partnership property and employment and it paying off. So it contains the partnership property must be applied and held by the partner for the partnership purpose as per the agreement prepared. It comprises property and interest, property actually purchased to the partnership, whether buying or otherwise, name of the partnership. Partnership property will be applied as paying debt of outsiders, paying back partners firm own than capital, paying capital retailable, ultimate residues is asset remaining. Thank you everyone for the listening us.